Good afternoon.
შუადღემშვიდობისა. ყველა თარგმანი უზრუნველყოფილია, ხომ ასე ამშვენიერია. მაშინ შუადღემშვიდობისა მინდა მოგესალმოთ ჩვენს პანელურ სესიაზე და ჩვენ ნამდვილად ძალიან მოხარული ვართ, რომ მართავთ აი ამ სესიას. ეს არის შესანიშნავი სესია, ორი ძალიან საინტერესო სესია გვექნება კონსულტაციასთან ადრეულ ეტაპზე წვდომასთან დაკავშირებით, რაც გახლავთ რასაკვირველია უკეთესი გზა ადამიანების უფლების დაცვისა, ვიდრე ადრეულად და ადრეულ ეტაპზევე მათი წვდომა კონსულტაციაზე არსებობს. ძალიან ბევრი პროცესი მიმდინარეობს მსოფლიოს მასშტაბით, იმასთან დაკავშირებით, როგორ შეიძლება ამ უფლებების უზრუნველყოფა და სტრატეგიების შესახებ ასევე, რომლებიც უზრუნველყოფს მათ დაცვას და ამ ჩვენი დღევანდელი პანელის ფარგლებში ჩვენ მოვისმენთ იმ სხვადასხვა პროცესების შესახებ, თქვათ მიდგომების შესახებ, რომლებიც ევროპაში და მსოფლიო მასშტაბით გამოიყენება ადრეულ ეტაპზევე წვდომის უზრუნველსაყოფად, ხელმისაწვდომების უზრუნველსაყოფად, ესე იგი იურიდიული კონსულტაციისა. მე მმართველი დირექტორი გახლავართ საერთაშორისო სამართლებრივი ფონდის და მე ჩემი კოლეგი არ არის წარმოდგენილი და შემდგომად მე ახლა უკვე დავასრულებ საუბარს და გადავცემ სიტყვას პირველი პანელის მომხსენებელი გამოვა Andrea Huberi, რომელიც წარადგენს დღეს სისხლის სამართლის რეფორმის ზეგავლენას სამხრეთ-აღმოსავლეთ ევროპაში 2005-2011 წლების განმავლობაში მას ეკავა პოზიცია ადამიანის უფლებათა ორგანიზაციების ხელმძღვანელის პოსტი და ევროპისა და ცენტრალური აზიის ლონდონში იყო წარმომადგენელი, ხოლო 2018 წლის ოქტომბერში და ბულოცავმა ამას მან უკვე გადაიბარა კანონის უზენაესობის სამსახურის ხელმძღვანელის პოსტი EU-ში და შესაბამისად გადავცემ მას Andreas გადავცემ სიტყვას. 1 წლის წინ გახლდათ ეს და შესაბამისად უკვე გარკვეული პერიოდი მაქვს მუშაობის. ჩემ მინდა მე გამოვიყენო ის კვლევა, რომელიც განხორციელდა სამხრეთ-აღმოსავლეთ ევროპაში გასული წლების მანძილზე, მინდა გამოვიყენო ეს მაგალითისათვის, საილუსტრაციოდ იმისათვის, რომ წარმოგიჩინოთ თუ ეფექტურ დაცვაზე ინკვიზიტორულიდან გადასვლის, ესე იგი პროცესუალური, ესე იგი წესები, კოდექსები და ასევე იმ მიღებული გამოცდილების შესახებ, რომელიც შეიძლება საყურადღებო და მნიშვნელოვანი იყოს სხვა ქვეყნებისათვის და მე შესაბამისად ვისაუბრებ ეფექტური დაცვის წინა სასამართლოს ხდომამდე ამ თემაზე და რომელიც გახლავთ მნიშვნელოვანი ელემენტი. მინდა ზოგადი ინფორმაციის სახით მოგახსენოთ, რომ 2003-დან 13 წლის ფარგლებში OSCE-ის წევრი ქვეყნები, ასევე კოსოვო შემოიღეს შეჯიბრობითი ელემენტები პროცესუალურ სამართალში, თუმცა ეს არ იყო ძალიან მასშტაბური და ამ უფლებამოსილების გადაცემის პროცესში გამოძიების ჩატარებისა გამომძიერი ბევრი მოსამართლიდან პროკურორზე და ეს ნიშნავს იმას, რომ პროკურატურა და დაცვა თანაბარ, ასე ვთქვათ, პირობებში ამზადებს საქმეს და მნიშვნელოვნად შეიცვალა შესაბამისად დაცვის მხარე. მტკიცებულებების შეგროვებისას უკვე იყენებს და არსებობს უკვე მიუკერძოებელი მოსამართლე. იმავდროულად უფლებები, რომლებიც აუცილებელია იმისათვის, რომ განხორციელდეს ეს დაცვა და შესაბამისი პასუხისმგებლობების განხორციელებისათვის მხოლოდ ნაწილობრივ აისახა ეს სისხლის სამართლის შესაბამის კოდექსებში ამ აღნიშნული ქვეყნების ახლახან ასევე დაფიქსირდა, რომ მართლმსაჯულების სექტორი სრულად ვერ აცნობიერებს თუ რა გახლდათ მისი შეცვლილი პასუხისმგებლობები დაცვის ესე იგი უფლებამოსილების გაზრდა წინა სასამართლოს დომის პირობებში დაცვას არ გააჩნია უფლებამოსილება შესაძლებლობა ან უნარჩვევები იმისათვის რომ შეაგროვონ თანასწორ პირობებში და შესაბამისად ეს უკვე ეჭქვეშ აყენებს ასე ვთქვათ რისკს უქმნის შესაბამის თანასწორ პირობებს და ასევე აისახება თავის მხრივ საქმის გადაწყვეტილებაზე. ძალიან მარტივია გავიგოთ თუ პრაქტიკაში ასეთი მიუკერძოებლობა რატომ შეიძლება დარჩეს მხოლოდ ქაღალდზე და რეალურად არ განხორციელდეს. საერთოდ ევროპაში პრაქტიკოსების მითითებით და ინფორმაციით პროკურატურა ვერ აგროვებს შესაბამის მტკიცებულებებს და მტკიცებულებებს როგორც ასეთი შეიძლება არ უმალავენ, მაგრამ ყოველ შემთხვევაში მამხილებელი და ბრალის განმსაზღვრელი ბრალეულობის ამსახველი მტკიცებულებების მოწოდებასთან დაკავშირებით პრობლემა არსებობს, ანუ გაიზარდა დაცვის უფლებამოსილება, თუმცა როგორც თქვი, სხვადასხვა გვარი იყო ამის მასშტაბი და ძალიან კომპლექსური და ძალიან შრომატევადია და იმისათვის რომ დაცვის პოზიცია მოამხსადოს, რასაკვირველია უნდა იცოდეს თუ ბრალმდებელმა მხარემ რა მოამზადა და ასევე უნდა მოხდეს შესაბამისი ექსპერტის ესე ვთქვათ გათვალისწინება. და უნდა მოხდეს ექსპერტის შერჩევის ვთქვათ ეჭქვეშ დაყენება ან უნდა მოხდეს ვთქვათ პროკურატურასთან მუშაობა იმისათვის რომ და საგამოძიებო ქმედებებიც მათ შორის ეს შეიძლება მოიცავდეს მოწმეთა ჩვენებების მოსმენისას და პროფესიონალი ექსპერტების მონაწილეობა ძალიან მნიშვნელოვანია ასევე დაცვისათვის, ანალიზისათვის კრიტიკული ფაქტების და იმისათვის რომ მოხდეს შესაბამისი მტკიცებულებების წარმატებით შეგროვება. დაცვის მომზადება ასევე მოიცავს კერძო გამომძიებლებისა და სასამართლო ექსპერტების ჩართულობასაც. სამართლებრივი ურთიერთობა შესაბამისად ძალიან მკაფიოდ არის განსაზღვრული. ახალი სამართლის პროცესუალური კოდექსის მიხედვით მნიშვნელოვნად გაიზარდა და იმავდროულად რაც არ უნდა გასაკვირი სულაც არ არის და ამ ახალი გაზრდილი პასუხისმგებლობების უზრუნველყოფა და შესაბამისად ეს რასაკვირველია თავის რაღაც შედეგებს ატარებს და გამოძიება შესაბამისად იმ მხარების მონაწილეობით ხდება, რომლებიც კონტრაქტით იქნებიან დაქირავებულები და ეს უკვე შესაძლებლობებზეც თავის ასახვას ჰპოვებს. აუცილებელი რესურსი, იურიდიული დახმარება, პროკურატურის მიერ მტკიცებულებების მოპოვება, როგორც აღნიშნე, პროკურატურის ესე იგი მიერ რასაკვირველია ბრალდებულის წინააღმდეგ იქნება მიმართული და პროკურორების ესე იგი ბრალდების მაჩვენებელი მაღალია საბრალდებო განაჩენის და შესაბამისად ეფექტური სისხლის მართლმსაჯულების სისტემისთვის ძალიან მნიშვნელოვანია და დაცვის მხარის მიერ ამ შეჯიბრებით სისტემის პირობებში კიდევ უფრო მნიშვნელოვანია იმისათვის რომ იყოს მხარეთა შორის თანასწორ უფლებიანობა და თანასწორ უფლებიანი პირობები და ეს შესაძლებელი იქნება მხოლოდ იმ შემთხვევაში თუ იქნება თანაბარი სახსრები, ასე ვთქვათ ფინანსური სახსრები ორივე მხარეს და სამართლიანი სასამართლო წინააღმდეგ შემთხვევაში დარჩება უბრალოდ ფიქციად და რაღაც არარეალურად. გმადლობთ ანდრია, მე ვფიქრობ რომ ძალიან საინტერესო განხილვა იყო, ძალიან საინტერესო პრეზენტაცია იყო იმისათვის რომ გარკვეული ზღვრები დაფიქსირდეს პროკურატურის და ბრალდების მხარეს და ასევე რა ქმედებები არის საჭირო იმისათვის რომ დაცვის მხარეს გადასადგმელი იმისათვის რომ ეს პროცესები სათანადოდ მოგვარდეს და გასაგებია რომ შეზღუდული ფინანსური სახსრების პირობებში და რესურსის პირობებში უკვე ეს საფრთხეს უქმნის აი ამ შეჯიბრებითობის რეალურად განხორციელდეს და როგორ შეიძლება ვთქვათ რაღაცნაირად შეიზღუდოს პროკურატურის ეს ვთქვათ უფლება მოსილება და იმისათვის რომ თანასწორ უფლებიანად მოხდეს ესე ვთქვათ და ახლა მინდა ჰანან ფათალას გადავცე სიტყვა იგი ისაუბრებს გესაუბრება თქვენ ტუნისის მართლმსაჯულების სისტემის შესახებ და თუ როგორ ხდება წინა სასამართლო ეტაპზე უფროსი კონსულტანტი ტუნისიდან, რომელიც ესე იგი ბრალდებულების დამცველად გამოდის და ასევე იგი ხელმძღვანელობს ტუნისის ძალიან მოწინავე საქმიანობას, ესე იგი პოლიციის განყოფილებებში და ამერიკის ადვოკატთა ასოციაციასთან ვთქვათ მუშაობს და ასე შემდეგ. გთხოვთ გადმოგცემთ ახლა თქვენ სიტყვას. شكرا جميعا.
السيدة نيكول استحقت بالعمل بالمؤسسة الدولية القانونية منذ نشوئها.
თარგმანი ჯერჯერობით არ შემოდის, ბოდიშს გიხდით, როგორც კი გადართავენ ფრანგული ენის თარჯიმნები, ჩემთან შემოვა უკვე შესაბამისად მათი თარგმანი ამ ქალბატონის სიტყვისა და შევძლებ რომ შესაბამისად ვთარგმნო.
დიდი მადლობა ყველას. $2014 წელს შევხვდი იურიდიული საკითხების შესახებ საერთაშორისო კომისიას. 2014 წლიდან ტუნისის რევოლუციის შემდეგ შევხვდი.
اندلاع الثورة
არაბული გაზაფხულის შემდეგ ტუნისის კონსტიტუცია შეიცვალა და ძირითადად მისი მთავარი აქცენტი იყო ადამიანების დაცვაზე ორიენტირებული და ის რაც გაკეთდა ტუნისის კონსტიტუციაში რაც კი მოხდა 2014 წელს ახალი კონსტიტუცია შემუშავდა ტუნისის რესპუბლიკაში, რომელშიც წინასწარი დაკითხვების საკითხები იყო განხილული და ასევე უფლებები, რომელიც უნდა ქონოდა ადვოკატს. მინდა აღვნიშნო რამდენიმე წინასწარი დაკავების, ანუ პროცესუალური საკითხები, რომელიც უშუალოდ შედიოდა ტუნისის ახალ კონსტიტუციაში. 2016 წელს ასევე ახალი ცვლილებები შევიდა ტუნისის კონსტიტუციაში. მინდა წარმოგიდგინოთ რამდენიმე ცვლილება, რომელიც ახალ კონსტიტუციაში იყო შესული და რომელიც უკავშირდებოდა სისხლის სამართლის პროცედურებს და იმ კოდექსებს, რომელიც იყო მიღული ტუნისის რესპუბლიკაში. თავის დროზე ტუნისის რესპუბლიკაში არ ყოფილა არანაირი ვთქვათ არ ყოფილა თქვათ განსაზღვრული 2016 წლამდე სპეციალური კოდექსი, რომელიც სისხლის სამართლის პროცესუალურ კოდექსებს ანუ დაარეგულირებდა ტუნისში. ამ შემთხვევაში უკავშირდებოდა წინასწარი დაკავების დროის შემცირებას და არ იყო შესაძლებელი ამ დროის შემცირებაზე საერთოდ საუბარიან განხილვა და როგორც წესი წინასწარი დაკავების საკანში ეს დრო, რომელიც იყო განსაზღვრული, ხშირად აჭარბებდა ხოლმე დადგენილ დროს. და შეუძლებელი იყო თუნისის სახელმწიფოში ეჭვმიტანილის დაცვა, მანამ სანამ მას არ გამოუტანდა სასამართლო ანუ განაჩენს. ეჭვმიტანილს არ ქონდა იმისი საშუალება ან უფლება, რომ მას ქონოდა საკუთარი ადვოკატი, მანამდე სანამ სასამართლოს წინაშე ის არ წარდგებოდა წინასწარი დაკავების იზოლატორში. და ყველაზე მნიშვნელოვანი, რაც იყო მიღებული ახალი კონსტიტუციის მიხედვით თუნისის სახელმწიფოში, ეს იყო, რომ ამ ეჭვმიტანილს მას მიეცა იმის საშუალება, რომ მისთვის დაენიშნათ ანუ ადვოკატი, იმ მიუხედავად იმისა, მას ჰქონდა თუ არა საშუალება, რომ საფასური გადაეხადა ადვოკატისთვის, მასი დამცველისთვის. და მანამდე თუნისის არაბული გაზაფხულის მომლენებამდე თუნისის სახელმწიფოში იყო შემთხვევა, რომ წინასწარი დაკავების საკანში ხდებოდა ხოლმე წამება, ან თქვათ გარკვეული ზეწოლა ეჭვმიტანილზე, დაკავებულზე და მას არ ჰქონდა არანაირი იმის უფლება, რომ საკუთარი თავი დაეცვა და რომ ყოლოდა ადვოკატი. და მას შემდეგ რაც თუნისის რესპუბლიკაში 2016 წელს მიიღეს კანონი, ახალი კანონი სისხლის სამართლის შესახებ, ზოგიერთ სასამართლოებში მაგალითად წინასწარი დაკავების საკანში თქვათ ის, რომ ადამიანებს ქონდათ უფლება ადვოკატის ყოლის 40%-ით გაიზარდა, ანუ 100-დან 40 ადამიანს უკვე ქონდა იმის საშუალება, რომ ყოლოდა საკუთარი ადვოკატი წინასწარი დაკავების პერიოდში. ის უფლება, რომელზეც მე ავხსენი და ვისაუბრო, ეს იყო ადვოკატის, ანუ დამცველის უფლებები, რომელიც მას ჰქონდა პოლიციის, ან თქვათ პროკურატურის წინაშე. და ამ ახალი კანონის შემოღებამ მოახერხა სწორედ ის, მოგცა იმის საშუალება, რომ ჩვენ გამოგვერკვია, ანუ ქალყური გვედევნებინა იმაზე, თუ რა სახის დარღვევები შეიძლება ყოფილიყო ეჭვმიტანილზე. და ამ ყველაფერმა ჩვენ მიგვიყვანა იქამდე, რომ ეს საკითხები მივიდა, განხილული იყო ადვოკატთა ასოციაციის წინაშე, ან და თქვათ სასამართლოების წინაშე. და ჩვენ ამჟამად ახლა მე წარმოგიდგენთ, ანუ სახელმწიფო საერთაშორისო ორგანიზაციების წინაშე იყო თქვათ ჩვენი ეს გამოცდილება მიტანილი. და თუნისის სახელმწიფოში ჩატარდა ესე რომ თქვათ გაერთიანებამ, ადვოკატთა გაერთიანებამ მოახერხა სწორედ ის, რომ ადვოკატებს მიაწოდა გარკვეული ინფორმაცია მათი უფლებების შესახებ. რათა ადვოკატებს შეძლებოდათ იმის განხორციელება, რომელსაც აი ამ გარკვეული შეხვედრების ან გარკვეული ტრენინგების დროს იღებდნენ, ასევე გამოძიების დროს ადვოკატს ჰქონდა სწორედ ინფორმაცია თუ რისი გაკეთების უფლება მას შეეძლო და რისი უნარები ჰქონდა მას რომ გაეკეთებინა. სახალხო ადვოკატების ასოციაციის წყალობით მოხდა ამ კანონის შემუშავება, რომელშიც იყო ჩართული ადვოკატები, რომლებმაც გააცნეს თავიანთ კოლეგებს ყველა თავისი უფლება, რომელიც ადვოკატს აქვს, განახორციელებენ ამ კანონმდებლობის დახვეწას. დიდი მადლობა.
დიდი მადლობა.
То, о чем мы говорили, очень важно.
Laws change for defense lawyers to change their practice to accommodate new laws, right? And in doing that, it's the importance of training and mentoring so that defense lawyers are actually providing quality representation as the practice changes, and how you've done that in Tunisia. So thank you very much. We're going to move now into a presentation by Dr. Lama. He's the Deputy Attorney General in the Judicial Prosecution Affairs and the Attorney General's Office of Afghanistan, and he is going to talk to us about the role of prosecution in facilitating the right to legal aid for the indigent accused. I'll turn it over to him.
Thanks very much for the UNDP for invitation of me in this conference, and the other organization for this conference, and the people and government of Georgia for the hospitality of the hosts of this conference. Because I know that about the problems of translation, I should try that I speak, I have my lecture in English. As have been mentioned, I am deputy.
Comme il a été souligné, je suis adjoint au parquet général en Afghanistan et entre le service de l'assistance juridique. Quelle est la différence? L'assistance juridique et le parquet, ils sont d'une même côté, de la côté de la justice, et eux, ils essayent pour assurer l'accessibilité à la justice pour les accusés, les prévenus et les suspects. Ils travaillent. Et l'assistance juridique en Afghanistan. Et la troisième partie.
In the first phase, as you know, that legal aid has been recognized, officially recognized in our constitution, in Afghan constitution. Article 31 of the constitution of Afghanistan have mentioned that each person can have, on the time of his or her arrest, can have the right to access to the attorney, and the defendant on the face of its arrest, he have the right to inform from the defend and from the accused to it, and in the time that the law certified it should be present in the court. The government obliged in criminal cases prepare attorney to the poor defendants, and the government obliged to prepare the privacy of connection between defendant and its attorney. In the criminal procedure code, also in Afghanistan, criminal procedure code also recognized the right to legal aid and right to attorney. In Section 8 of Article 7, having attorney or legal aid have been mentioned, have been enumerated, one of the rights of the suspects and accused. And in the way of, in order to prepare the equality of arms, Section 11 of Article 7 of this code have been mentioned that the suspect and defendant have the right to see the decision of the primary court, appeal court, and to see and review the testimonies and physical documents and related documents and the forensic reports and the surveillance order and the order to search of his or her home, and the suspect and defendant have the right to enough time and is proportion facility for the defendant himself, except in conditions that it is against the national profit. Also in Section 12, the suspect and the defendant have the right to object to the order and activities of the police, of the prosecutor, and the court, and the experts. And in the 14 part of this article, have we mentioned that each suspect and defendant have the right to have connection with his attorney or legal aid provider have connection secretly, written or orally. And in the second phase of my lecture, I should mention that in Afghanistan from 2005, established Bar Association. In 2005, for the first time, we have the election of the Bar Association, and the second election now, in this year, we have the second phase of the election of Bar Association in Afghanistan. And Bar Association in Afghanistan have independently and actively have their activities for defending from the rights of the suspects and defendants. On the second phase of my lecture, I should mention that now in Afghanistan, the Prosecution Office, Attorney General Office, and Bar Association have near cooperation for access, preparing the ground of access to justice for the defendant and suspects. Now in AGO of Afghanistan, we work with 4 categories of the legal aid activists. The first category, the legal aids which belong to Bar Association. The second category, which the legal aids which belonging to the Ministry of Justice. On the third category, we have relationship and being colleague with the some legal aids that they are active in legal aid, but not related, but not dependent to Ministry of Justice. They are independent. Perhaps they funded or supported by the international NGOs, which in Afghanistan is active. And on the fourth category, we have some cooperation with some legal aid presenters with active for the violence against for fighting violence against women. So it is my short lecture. I am ready for any question. Thank you very much.
Thank you very much. I think that, you know, again, this theme of equality of arms, and it's important that you said we're on one side, and that's the side of justice, right? And I think that that's so important to highlight in this space. And it's great to know that in Afghanistan, the Attorney General's office, does not act as a barrier to access to justice, right?
Exactly.
It supports confidentiality and supports, access to information. That's so important when we are talking about early access and cooperation between parties. And so that's great, and thank you for sharing. We're actually going to move off script and introduce Mr. Stefan Schumann. Stefan is going to be highlighting the transnational empirical research in Europe and the recent implementation efforts due to the EU Directive on Legal Aid. Just a bit about Mr. Schumann. He's an assistant professor at the University of Linz in Austria, the deputy head of the Department for Corporate Criminal Law and Criminal Justice. He is a lawyer and a member of the Fair Trials Legal Experts and Advisory Board. So we'll turn it over to you.
Thank you. I'll try to stay brief, and I have the chance to jump on the presentation of Nora Katona today in the morning. She spoke about the Austrian system, and at the beginning, and underlining the need for emergency defense lawyer schemes for a really effective access, early access to legal aid pre-trial. Some figures. We did a study a few years ago asking professionals about their experiences, how often access to legal advice pre-trial happens. We asked police officers mainly, we asked judges, we asked prosecutors, as well as defense lawyers. These are the figures for Austria. You see more than 80% said it seldom or rarely never happens. These were the experiences, and those experiences are underlined by statistical data, empirical data. Colleagues of us worked out in another study. They were evaluating more than 5,000 file cases looking on the pre-trial stage, and were searching for indications whether a suspect at any stage of pre-trial proceedings was represented by a lawyer. In more than 90% of the cases, there were no indications for that. And going more into the details, whether the defense lawyer or any defense lawyer was present during the interrogation, it have been 98% where no indications for the presence of a defense lawyer at the pre-trial interrogation was to be found. Given that, and coming back to my first slide, this is a slide I took from the representation of the results of our study we did these few years, about 8 years ago. And we ask why there is typically no defense lawyer present at pre-trial stage. First, to roughly highlight it, 3 points. The police side, the providing of information is typically or often insufficient. It improved over the last years, but still there are some things to make it better. On the contrary side to that, there's an information asymmetry with the suspects. They underestimate the importance of pre-trial stage, as well as the criminal procedure at all does it. It underestimates the importance of pre-trial from a conceptual phase, given the fact that most cases end in pre-trial stage and will not even reach main trial. And the very last point, and probably one of the most important points, the money or the lack of money. This leads us to the question of legal aid. And here I would like to add that there's a study in Germany done a few years ago about the effectiveness of legal aid for those being in pre-trial detention. And it showed that the length of pre-trial detention will impressively decrease when the suspect is represented by a lawyer. And given the fact that each day in prison costs in Austria 125 euros, it might be even a chance to save money when spending money on legal aid at this stage of proceedings. I called it the magic triangle of access to legal advice. You have to have the right, you have to have the information, and you have not only to have the availability, but the accessibility. And if we look a little bit more on those, accessibility means legal aid, and it means practical tools, especially emergency defense lawyer schemes or public defender schemes at the early stage pre-trial. There is a strong relationship between legal aid and mandatory defense. And there are even countries like Germany where you have legal aid and mandatory defense strictly connected to each other, and where have only afterwards, after the proceedings ended, the decision on whether the merits test, the means test is passed, whether the suspect will have to pay for a defense lawyer once mandatory defense was applied. In Austria, we have a not so strong, but also a strong relation between mandatory defense and legal aid, and that's why I'm going to mention it. You know the classical test of means and merits for legal aid or not for not providing legal aid. The means test is so far no problem in Austria. When on the other side we have the merits test, it means we provide legal aid when it's in the interest of justice. And here we come to the mandatory defense. It's in the interest of justice in each case where there is a case of mandatory defense. And additional to that, when the suspect is blind, deaf, dumb, or in other ways impeded to defend himself, in remedies procedures, and if the difficulty of the case due to the facts or to the law demands so. The later one is rarely applied. So at least pre-trial mandatory defense is the typical reason for providing legal aid if necessary. But mandatory defense pre-trial rarely happens beside cases of pre-trial detention, which means in cases where you do not have pre-trial detention, you typically will not have access to the normal, the ordinary legal aid system. When we take a small look on the legal aid, on the structure of the legal aid scheme, legal aid is ordered by the court on application or ex officio. But the lawyer is chosen by the bar, which is kind of a guarantee should be kind of a guarantee for the independence of the lawyer. However, it has some downsides, because it takes a while until you will have a legal aid lawyer. It takes the court order for legal aid. It takes to provide the court order to the bar. It takes the time of the bar to decide on and to choose the lawyer and to inform the lawyer. Typically, it takes a few days. Given the fact that you have 48 hours at max at police arrest station, you have additional 48 hours at max at judicial detention stations, the judicial detention facilities, until the decision on pre-trial detention has to be made or not, it will be too late. So there is an urgent need for an emergency system complementary to the traditional legal aid system. We have such a system, as Nora briefly described today in the morning. The former pilot project on a defense lawyer scheme, since the implementation of the Access to a Lawyer Directive in 2017, is extended to the judicial hearing on pre-trial detention. And this is really a great success, and we were really in need of that. And then we got a cut, and afterwards there will be the decision on mandatory defense. Once pre-trial detention is applied, you will have a mandatory defense, and if necessary, you will have legal aid. Here you got a point, probably it's not to be read, but you will find it in the materials afterwards. That's the information sheet on the standby legal counseling service, and you can find your first call will be free of charge. There's another point on whether somebody will take the chance for calling the lawyer. It's the information beside. It's the information whether it's worth to call a lawyer. And there you, just the last slide, okay. There you have a difference between the law and the information by the police. The law says, and I put it in German on the slide, but I will translate it briefly. The law in the upper section says the suspect has to be informed that his statement may be used for his defense, but also may be used against him as a proof. The information letter of the police says you have the right to remain silent. However, you should think about that your statement may significantly contribute to your defense, and you might miss the possibility to bring in your view of the things and to clarify, and by that shortening the length of pre-trial detention. If you contribute with your statement to the finding of the truth, it will be a mitigating circumstance. And now you might think about whether you now decide to remain silent and decide to call a lawyer or not. I'm skipping my conclusions because I think it became obvious. Thanks for listening to me.
Thank you. Thank you very much. I think that this highlights the importance of research and data-driven evidence to discuss these issues of early access and how we can use evidence to then reform systems and create structures that lead us to have better protections of the right to early access. And I also thought it was really interesting that you highlighted a pilot project. I think pilot projects are a really great way to see what works, make changes, and scale up from there. So thank you very much for your presentation today. So actually I'm going to turn it over now to, I said in the beginning we had a panel within a panel, so now I'm going to turn it over to our panel within a panel. So I'm going to turn it over to Zaza Nomuradze, who's the director of Open Society in the Berlin office, and he's going to be introducing the findings of research conducted by Justicia Criminal Rights Network on access to legal aid and police custody in Europe. So we're really interested to see what you all have to present.
Yes, thank you so much. And it's a great pleasure to introduce the team, which is going to present on the findings of the research. But I thought I would make a quick introduction of that research. Statistically, I think everywhere, perhaps in the world, most criminal cases start with police arrest. And what happens during the first hours and first days of police custody have critical and decisive impact on what will happen to that person. In order for that process to fit the requirements of fair trial, many things need to happen during police custody. There are many safeguards that suspects are given by law, but those rarely work in practice. Maybe they are as facts happening, but the nature of the realization of the rights would not qualify that those rights exist. Critical rights would be right to be informed of your rights, right to remain silent, and the ability to exercise that right, right to have interpretation and translation if you don't understand the language of the proceedings, right to have access to a lawyer, right to have legal aid, so on and so forth. So interaction of those rights is really critical. We talk a lot about effective legal aid. Yes, effective legal aid is essential, but effectiveness of legal aid will be undermined if other interconnected rights are not effectively provided. If the person cannot exercise effectively the right to remain silent, there are limitations on what lawyer can do when she or he comes to the police station to assist the person. If there is no effective access to case file and to see what are the charges based on which person may be prosecuted or put in pretrial detention, there is not that much that even very good lawyer can do. So therefore, it's really critical to look at those rights in interconnected ways, and also to understand what are the roles of different actors to give space to the realization of the right. At the previous panel, at the plenary, I made a comment really welcoming the presentation of the Deputy National Head of the Police of Ukraine, and saying how important it is that we engage with police and understand their perspective of this matter, because the suspects are in police custody. Police are the first people who should inform people about their rights, and so it is in their hands how those rights are going to be really given meaning. Police operate under so many their own procedures and guidelines, and we really need to also understand what are the constraints on their bureaucratic practices, what kind of incentives or lack of them drive particular behaviors that limit realization of defendants' rights. So that was really the motivation behind really designing the research to help us understand what happens in practice during police custody and understand the motivations of different actors for the behaviors that they demonstrate in conducting their work in particular ways. First of all, starting with police, but also the defense lawyers, prosecutors, investigators, judges, and other actors if relevant. So the research that was designed by Justicia European Rights Network focuses on 9 countries. It was established about a year and a half ago, and real innovation in this research was to use a quantitative empirical research method to secure presence of researchers in police stations so that they could continuously observe how different actors behave during police custody phases. So the idea was that in addition to interviews, focus groups, desk research, there would be this really very important component that would document the actions, behaviors during arrest and detention phase, and to be able to observe lawyer suspect meeting, as well as possibly to be present to observe the interrogations. So the research was introduced in 9 countries. As you could imagine, research of this kind would require agreements with police leadership to allow researchers to be based in police stations. Obviously, we prepared our confidentiality protocols to guarantee that that information would be used only for research purposes and no personal identification would be possible. The research of this kind was done before that in 3 countries that we were very much engaged with. That was Ukraine, Georgia, Moldova. Before that, originally, it was implemented in England, France, the Netherlands, and Scotland. We were really disappointed that, unlike those previous research projects, only 3 countries out of 9 secured full agreement or full access to the police stations for research purposes. In other 6 countries, there were different degrees of kind of admission of researchers, or no admission at all to participate to really conduct this research. The findings will be presented on the 4th of December in Brussels. The research was designed particularly to look at 3 directives that the European Union adopted and entered into force by the time we set up this research. So it was a directive on access to right to interpretation and translation, letter of rights, and access to a lawyer. Though the research findings also enable to make some initial comments also on the implementation of right to legal aid, which has not yet fully entered into force. It was adopted in 2016, but transposition only will end next year. So the 3 directives were the focus of the research, and now the colleagues from Justitia, from Spain, from Bulgaria, from Hungary, and Italy will present some initial findings. So each of them will have 3 to 4 minutes, I think. Yeah. 2 to 3. Okay. 3 minutes. 3 minutes. So we will start. What is the order? So first one, Spain. So Patricia Guerchera is the co-director of the Rights International Spain, and she will present the findings from Spain. Patricia, 3 minutes.
Hello.
Yes.
Can you hear me?
Yes.
Yes. So hello everyone. We carry out this research specifically in the Basque Country. I mean, empirical research was carried out in the Basque Country that has a region that has its own police force, and that's because they were the only ones who granted that access to their police premises. As far as the right to interpretation, I'm going to speak very quickly. They do have, the regional police force does have letter of rights translated in a number of languages, but for some reason they don't provide detainees with those translated letter of rights. But they inform them of their rights in Spanish and tell them that then the interpreter will come later together with a lawyer and explain them and translate them orally and explain them in greater detail. What this is absolutely not compliant. Again, we don't have a specific mechanism or guidelines to identify the need for translation and interpretation, but I think this is a common problem in most jurisdictions. And in spite of the fact that the recent reforms provide for an official register of translators and interpretations to be created, it has not yet been created, and these activities of translation and interpretation have been partially outsourced to private companies, which sometimes poses problems of quality. As far as the right to information is concerned, the letter of rights, although it exists, and it is provided to detainees, it is not drafted in what we consider to be an accessible language because it merely reproduces the text of the law. Although the legislation says that detainees would be allowed to keep a copy of the letter of rights while they are in detention, as provided for in the directive, in practice, police officers do not allow them to keep a copy based on security reasons to avoid them to harm themselves or harm third persons. They also apply a narrow interpretation of essential elements in order to challenge the lawfulness of the detention, so essential elements to know the reasons of the arrest. The legislation refers to elements and not documents, as the directive does, and police officers do give oral information, although in some cases police officers may be willing to disclose documents, but they're not obliged to do so according to the instructions they received from their bosses. And finally, access to a lawyer. In Spain, it is mandatory to have access to a lawyer for any person who is under police custody, with only one exception in the case of road safety offenses. But for some reason, this specific police force considers that when the detention is based on an arrest warrant issued either by a national judge or a European arrest warrant, there is no need to call a lawyer to assist the detainee. This exception is absolutely unjustified. There is no legal provision or internal instruction that allow them to do so. And when it comes to lawyers, we have identified that few of them have interiorized the possibility that is now allowed to in the law as a consequence of the transposition of the directive to hold an interview with a client before they are interrogated by the police. So for some reason, they keep acting as they used to with the previous legislation, and they only hold private interviews after the interrogation by police. And I think I'm in time.
Patricia, thank you so much. Krasimir.
No.
Yeah, so please, presentation. So Krasimir Kanev, Chairman of the Bulgarian Helsinki Committee on Bulgaria.
Thank you. Of all the countries that took part in this project, Bulgaria had the lowest level of transposition of the EU directives, of the roadmap directives. And the key for understanding of why is this so is to understand the nature of the police detention in Bulgaria. Police detention in Bulgaria is administrative. It is not part of the criminal procedure. And as an administrative detention, you can appeal separately in an administrative court against this detention. It can last 24 hours, and it is administrative. And the government is reluctant to recognize that it is part of the criminal procedure and that the roadmap directives apply to this type of detention. We're talking here of the detention where there is a suspicion, there is data, as the law says, that the person had committed a crime. We're not talking here of a detention of a person who is drunk, or a person who is mentally ill, or a person who is detained for other purposes, a child detained for the purposes of educational supervision. We're talking here of detention that is based on reasonable suspicion that the person had committed a crime. This is why the roadmap directives do not officially apply, and they are at a very low level of implementation during police custody. And also we have a very low number of lawyers taking part in police activities. Although during police detention, you can be interrogated. The law does not talk about interrogation. It talks about investigative talk. But that is in fact interrogation. And it can go to your criminal file. Not directly, because it's not part of the criminal procedure. Whatever you say, it cannot go to your criminal file, but it can go indirectly through the testimony of the police officers. And we have had recently, this year, in March 2018, a judgment of the European Court of Human Rights of exactly the same situation. A person who confessed during this administrative detention in police. He confessed of a murder. But subsequently, when he was officially charged, he did not confess at that point. But the police officers who interviewed him during police detention were invited by the judge as witnesses. And on the basis of their testimony, he was convicted. So this was the case of Dimitar Mitev v. Bulgaria. So the court said indirectly, actually, this goes to your criminal file. You cannot say that it doesn't. So many gaps coming from this, stemming from this situation. No information on the right to silence, no prohibition of interrogation of the detainee. If the detainee wants a contact with the lawyer, this is a key guarantee, by the way. No legal aid, or rather no mandatory legal aid for vulnerable groups. No written translation of documents. No letter of rights in a language which the detainee understands. And, of course, a lot of physical abuse. So these are, in sum, findings on Bulgaria. And thank you very much.
Yeah. Thank you, Krasi. Andras Kader, co-chairman of the Hungarian Helsinki Committee.
Hello. Decided to just talk about one issue because of the lack of time, and that is actually notification of lawyers and how the directives, how the access to lawyer directive has brought along positive change in regard to that. We at the Hungarian Helsinki Committee did research, case file research in 2009. We looked into very severe cases, 150 case files, homicide, fatal bodily harm, and so on and so forth. And we looked into the percentage of lawyers appearing at the first interrogation of the defendant. And we found that legal aid lawyers were present at the interrogations in only 16% of all these cases, and we know how important first interrogations can be, and we also know what kind of pressures police can exercise on defendants, on suspects. And one of the problems that caused this was the practice of late notifications. We had clients who were arrested in the afternoon, but for some curious reason interrogated only 2 a.m. and in these cases it often happened that the lawyer got a fax into his or her office after midnight, and surprisingly he or she couldn't show up for the interrogation. So we, based on our research and based on the general principles and some specific provisions of international law and also the Hungarian constitution, were pressurizing courts to actually put an end to this practice by deeming evidence coming from these interrogations inadmissible, but for a very long time there was a reluctance to do so. There was this kind of understanding from judges with regard to these police practices, and then Constitutional Court decision came, and then a Supreme Court guideline was issued which said that if the time between the notification and the procedural act is insufficient, then the evidence should be deemed inadmissible. Now, obviously, insufficient is a very flexible term, and this is where the directives come into the picture, because when the transposition, the implementation discussions went on, there was a debate on how much time should be actually reserved for the lawyers to appear. Finally, there was a change in the Code of Criminal Procedure as of July this year, which says that at least 2 hours must pass between the notification and the procedural act. So the police are now actually obliged to wait for at least 2 hours. It's not always sufficient, and I don't know whether this was a good result eventually, or whether judicial discretion would have been better, but at least this is a standard that now we can call the police to account for. And also 1 hour of consultation is now in the law, and I regard this, especially in the light of the past, a positive development. I think that's, well, 3 minutes is enough for this and no more. Thank you.
Thank you, Andras. And next one, next presenter is on Italy, Alessio Scandura, who is from the association Antigone.
Thank you. Very briefly, we were among the countries that were not authorized to enter police station at any capacity. So, on the other hand, in our system, there is no police interrogation in the police station. So basically, when you're arrested, no one tells you what's happening, basically. What they say is, tomorrow you will meet the prosecutor, you will meet the judge, they will tell you. So there is no police interrogation. We interviewed 111 detainees coming from the validation hearing, which is the first moment in which information are released, and 64 lawyers coming from validation hearings. Some findings, you have there some findings. 1/3 of the interviewees were assisted by ex-officio lawyers. This is validation hearings. It's not legal aid. It's people that show up at the hearing. They do not have a lawyer. The court appoints a lawyer for them, but that lawyer should be paid by them. 80%, more than 80% of those people are foreigners. So we are talking mostly, the big issue here is regards obviously foreigners. And for them, then the legal aid procedure is launched, and maybe legal aid will be granted or maybe not, depends. In 1/4 of the cases, lawyers say that they had less than 5 minutes to talk with the client and see the file. That's the main issue. We are talking about the validation hearing, which is the moment where the first decision about pretrial detention is taken, and we know how pretrial detention can affect the rest of the proceeding. At that stage, 25% of the lawyers say they have 5 minutes to look at the file and talk with the client. They have the right to go into police station, but they don't go because there won't be any interrogation. So that's the result. Sometimes neither the lawyer appointed by the defendant nor the ex-officio lawyer that should be appointed by the court according to a pre-established list show up. So the court appoints a third lawyer, someone else, and that's, in those cases, it starts a sequence of changes of lawyer all throughout the trial of the person, which makes the quality of the defense obviously very, very questionable. 38% of the interviewees did not receive the letter of rights. We have been informed about police stations that do not never give the letter of rights. They keep it. They read it, but they keep it. So the defendant do not. And many defendants were not informed about. They were not aware about their right to legal aid or their right to inform members of the family. What they know is that they are entitled to have a lawyer, but not much more than that. Translation. In 1/4 of the cases examined, when the interpreter showed up, that was very late, and so there was no time to support the lawyer during the first talk with the defendant. And in general, there is a very serious lack of confidence towards interpreters. Both judges and lawyers don't like to resort to interpreters because they don't trust them. Thank you.
Thank you very much, and back to you, Nicole. Thank you.
That was great, and I think that, you described it, Zaza, as the motivation behind this research was to help us understand what happens in practice in police custody, and that's such a straightforward description of what you were trying to get at. But I think that it allowed for some fascinating information to come out, and that could be used to help develop systems in these countries. And kind of linking it to Hanen's presentation, it sounds like just as defense lawyers need to accommodate kind of new laws and new practices, research needs to do that as well, right? Research needs to be done. It needs to be responsive to new laws to make sure and to study what's actually happening to make sure that laws are actually being implemented. So that was great, and we appreciate all of our presenters on the panel, and we have about 15 minutes for questions and answers, and so we'll just go ahead and take 3 questions at once and then have our panelists answer. So we'll start here and then just move across that second row.
Merci. Bonjour. Merci pour cette présentation de différents droits comparés. Je suis Yassine Younsi, avocat et président de l'Association tunisienne des jeunes avocats. En effet, j'ai une question pour Hanen. Est-ce que ILF, selon vous, a-t-elle réussi sur le terrain? Autrement dit, y a-t-il des résultats concrets par rapport à la représentation des personnes démunies, donc les pauvres, en application de la loi numéro 5 de 2016?
Okay, shukran.
Well, actually, we're going to do 3 questions. So we'll take the 2 questions that were here.
Okay.
У меня вопрос к представителю Афганистана. Вы сказали, что в 2005 году у вас была создана адвокатура. У меня вопрос. Сколько сейчас адвокатов в Афганистане? И с какого момента адвокат имеет доступ к подозреваемому? Могут ли они встретиться до первого допроса?
Okay, good evening. Hello, good afternoon. I'm from Mongolia, Mongolian Bar Association. I have a clarification or your opinions about it with regard to the Bulgarian presentation, because you mentioned about the administrative detention, because in Mongolia, our advocates also now face the similar problem that police call clients, well, I mean the convicted or the witnesses or the victims, and then first it's not an interrogation, it's not a procedure, and there is no need, so the rules applicable, standard rules are not applicable. So because it's not a part of the criminal procedure, and therefore it's like just like a clarification, and then they ask, get some information, and after some time they make them like an accused one, and use that information against them. So and in just an administrative, the questioning, the lawyer is not provided, so it looks like similar, and how to deal with it, and how you plan to deal with it, and what is the perspective of European countries in terms of this kind of situation?
Добрый день всем. Елена Дворецкая, Казахстан. У меня вопрос к представителю Италии. У вас сейчас в презентации прозвучало, что много иностранных адвокатов защищают права подозреваемых в Италии. Я хотела уточнить. Да, Италия. Вопрос к... What? Ну мне просто дали право задать вопрос, я поэтому... Он вышел, да? Извините. So I can continue? Okay. Я хотела уточнить, вы сказали, что очень много иностранных адвокатов в Италии защищают права подозреваемых. То есть это перевод был не так или что? Или действительно иностранные адвокаты вправе участвовать у вас в Италии?
Okay, so we are going to go ahead and take all 4 of those questions, starting with the question for Hanen, and then we'll move on to the question for our representative from Afghanistan, Bulgaria, and if the Italy question is still on the floor, we'll finish with that. If everybody can just take no more than 2 minutes so that we don't run over time, that'd be great.
Okay. سأجيبك في دقيقة واحدة فقط أعطيك مثالا أنه نبت عدد 27 مشتبه فيه أمام باحث البداية قبل اتخاذ أي قرار في شأنه من قبل النيابة العمومية. في 27 مشتبه فيه فقط حالة واحدة تم أخذ القرار الاحتفاظ بها وتم الإفراج عنها في أول جلسة محاكمة، أي أن 26 مشتبه فيه بقوا في حالة سراح. أيضا قمت بنيابة عدد 2 من أجل جنايات وهي الجرائم الأخطر، ولكن بعد اتخاذ قرار الاحتفاظ فبعد نيابة ILF للمشتبه فيهما الأول تم إبقاؤه في حالة سراح من قبل النيابة العمومية، والثاني تم إبقاؤه في حالة سراح من قبل قاضي التحقيق. شكرا.
According to the question which presented related to my speaking, I should say that as you know that in Afghanistan there are a lot of problems, especially the major problem is non-security, which is caused by the Taliban, by the Daesh extremists. But there is a lot of lawyers and attorneys and legal aid providers that they are active and they serve to the people, to the poor peoples, to the marginalized peoples. And the government of Afghanistan support these legal providers and the attorneys and bar associations. In now a situation, we can say that there is thousands of lawyers in Afghanistan that they try to present the legal aid to the defendant, to the suspects. Of course, we cannot say that all the peoples, the persons that need, certainly they access to justice, because there are a lot of problems. There are illiteracy, there are non-security, but among all of these problems, the government and the people of Afghanistan try to access to the justice. Thank you very much.
Thank you. And
Administrative detention by the police is possible. The police can detain persons administratively for different purposes. A foreigner without documents, they can arrest him or her for the purposes to be expelled or for other purposes, or a child abandoned on the street. This can also be an administrative detention. But administrative detention for the purposes of grounded on data, of a person for having committed a crime should not be possible. Therefore, this type of arrest and detention should initiate criminal proceedings from the beginning. And this is how it works in many countries of the world. I'm surprised that you have such situations in Mongolia. I thought that Bulgaria is the only country that does this in the world. So therefore, we should first find out about the ground for detention. And in the international law, and it should be the same in the national law, they should be provided for one by one, and they should in national law be no more than under the international law. How do we deal with such situations? Well, in our case, we are most likely to face infringement proceedings in the Court of Justice of the European Union. They have already been initiated by the European Commission. But for Mongolia, I don't know. Well, this case that we have, Dimitar Mitev v. Bulgaria, you can take a look, and maybe you can make use of it for your own purposes in a way of international litigation.
Among these people, 80% are foreigners. And in general, throughout all this research, we found that all the guarantees to in terms of procedural rights become weaker and weaker when we talk about migrants.
So the microphone system is out, that's fine. I don't know if we have, is there one last question? Okay, now it's on. If there's one last question? Okay, there's not one last question. That's perfectly fine. Okay, here.
النيابة العامة من تونس باش نقدم توضيح سري اللي قدمته الأستاذ حنان بخصوص تجربة مع الإيام في تونس ونحاول نجاوب شوية على تساؤل الأستاذ في تونس.
Can you give us 1 second? There's no translation. No, we don't have the English translation.
Oh, yeah, okay.
Okay, now it's here. I'm sorry.
قلت حبيت أقدم توضيح على الأستاذ وجوابا على تساؤل الأستاذ. منذ بداية مؤسسة ILF في تونس تبنت وزارة العدل في تونس والانضباط الفكرة مع توسيع دائرة النشاط والمساعدة القضائية اللي كانت فيما مضى محدودة نسبيا. وتخرجت في عمل مع مؤسسة ILF. تم عقد كما يذكر الأستاذة وبقية أعضاء المنظمة مؤسسة هذه اجتماعات المحل المحكمة خاصة وتحديد الأهداف المزرعة إنجازها وتحقيقها. تم تنظيم كذلك زيارات لعدد من مراكز الشرطة وتحسيس رؤسائها بأهمية المساعدة القانونية ومعاينة على كثافة الوضع داخل المراكز هذه والإجراءات المعتمدة. تم كذلك عقد لقاءات واجتماعات مع كتابة المحامي لتحسيسهم كذلك بدور المحامين في مجال المساعدة القانونية أثناء المحاكمة. بعد فترة من بداية التجربة عينا في المحاكم وفي القصة التي أعلن بها من خلال كل هذه الأطراف من كتبة وشرطة في التجربة، وأصبحت الشرطة تتصل بمحامي مؤسسة ILF. وذكرت الأستاذ حنان أنها كانت تحضر مع منوهة المعوزين بمراكز الشرطة للدفاع عنهم وحضورهم أمام المحكمة. كما لاحظنا كذلك متابعة محامي المؤسسة ILF بالمحاكم وحضور لجلسات المحاكمة كذلك. ما زال العديد من الأشخاص تم اعتقالهم في تونس قبل المحاكمة ولا يجدون الإمكانيات التي تقوي لهم الاستعانة بالمحاكمة. هذا من جهة مرة فما عدم حرص كامل من الشرطة لذلك والانخراط كذلك في المساعدات، ومن جهة أخرى غياب إلى حد التاريخ كيفية التعهد بأتعاب المحامي الذي يتعهدون بطلب من الشرطة مراكز الشرطة. التجربة ما زالت في بدايتها نسجل بعد تقدم هذا بمساعدة ILF إلى أن جميعا بمزيد دعمها نطمح جميعا بمزيد دعمها لتحقيق النتائج المشروعة.
Thank you so much to the comments from our colleague from the Attorney General's office in Tunisia. So I want to thank the panelists. I thought it was very interesting today. I hope you all thought so as well. You know, really the focus is on responsive research and responsive representation and how to use both to impact systems. Right, and we think the focus on early access is critically important because all of today has been about how it is the most critical stage of the case. And so the work that you all are doing is to be highly commended, and we thank you for your participation today. And thank you all for listening and for engaging.